I see people are joining us now, so we'll just wait a few moments till a few more get in here. Welcome everyone. My name is Leslie Lampton. I work at the Ridgefield Library and I'm happy to welcome you all this morning. This program is part of our Skills Box Tools for Business Success series, which we co-sponsor with the Ridgefield Chamber of Commerce, so I'd like to thank them as well. Today it gives me great pleasure to welcome Amber Forrest and Andrea Barton Reeves from Connecticut Paid Leave, and they will take it from here. So thank you.
Thank you, Leslie. It looks like someone had their hand raised. I'm not sure if that needed attention or not.
I don't think there's much we can do about somebody who raises their hand, I don't believe.
Okay, that's fine.
I might have done that by mistake, so I think
All
we're
right.
in good shape. We'll just
Okay. All right, thank you. All right, good morning, everyone. My name is Andrea Barton Reeves. I am the CEO of Connecticut's Paid Leave Authority, and with me today, I have Amber Forrest, who is our agency's executive assistant. So thank you for the opportunity to talk to you about Connecticut Paid Leave. I'll be making a presentation that will take about 25 to 30 minutes, and then we'll have the rest of our time for questions and answers. If you have Q&A in the meantime, please use the Q&A feature and not the chat feature, because that allows us to track questions and respond to them directly, which is not a capability that's available in the chat feature. So I will start and we'll get going. Thank you. So I'm going to share my screen and we'll go.
You're all set.
Thank you. Trying to get it to go. Come on. There we go. All right. So just a little bit about me. I started in this role as the Paid Leave Authority CEO about a year ago. And prior to coming to the Paid Leave Authority, I was the president and CEO at HARC, which supports people with intellectual disabilities and their families. I've done a few things in the community. I am originally from New Jersey, but I've called Connecticut my home for the last 25 years. I have a degree in English from Rutgers, and I have a law degree from the New York Law School. They will talk about the paid leave program, give you an overview of the leave laws and the role of the employer, how a person might apply for paid leave benefits, and give you a brief review of how it works in the workplace. There is also an option for employers to provide their own plan in lieu of participating in the public plan, and we will talk about how that works. Registration, which is required, additional resources so that you can communicate this to your employees, and questions and answers. Let's start by talking a bit about the Paid Leave Authority. We were created by statute in July of 2019, and the idea is to provide financial relief for families who need to take time off to care for themselves or their loved ones without having to worry about lost income. And we do that by providing pathways to accessible paid leave benefits. And we also try our best to support employers and administrators and healthcare providers to navigate the program. We have 5 primary responsibilities. Those include outreach and engagement, which we're doing today by having an opportunity to speak with you. We develop the policies and the procedures that are needed to administer the program. We also establish the trust fund contribution rate, which is no higher than 0.5%, and we receive the contributions that are being collected, having started on January 1 of this year. We approve and audit private plans, and we also administer the claims for those paid leave benefits. Here are some key dates that you should be aware of. First of all, in November, we opened the registration process for employers. Employers need to register so that we are aware that you are collecting the 0.5% of wages, which should have started on January of 2021. It is also the way in which you will remit those withholdings to the Paid Leave Authority. They don't go to the Department of Revenue Services or the Department of Labor. We're now reviewing private plans that employers are submitting, and there's still time to be able to do that. For the contributions that are being collected, they are due 30 days, which is a grace period after the end of the quarter, on the dates that you see listed on the slide. Starting in December, our goal is to be able to have employees, sole proprietors, and self-employed individuals begin submitting their applications for benefits so that those benefits can be accessed in January of 2022. Which employers are required to participate in the plan and which are not? Most employers are known under the statute as covered employers, and those are employers that have one or more people working in the state, even if your business is headquartered elsewhere. And that does include nonprofits and private sector employers that have a unionized workforce. People who are sole proprietors or self-employed individuals have the option of participating in the program, but if they do so, they have to remain in for a minimum of 3 years. Sole proprietors who actually employ others individually have the choice to opt in, but their employees must be registered to participate in the program. Let me not use the word registered. They must have the 0.5% withheld and remitted so that they are participants in the program. Those employers that are not covered include the federal government. Of course, we have no jurisdiction over the federal government. Some state of Connecticut employees, except for those that are covered public employees, and I will identify and define those in a moment. And the same is true for municipalities and local or regional boards of education, unless they too have covered public employees. Non-public elementary or secondary schools, essentially meaning private or independent schools, are exempt from the paid leave program because they have always been exempt from family and medical leave coverage. Covered public employees are defined as those that are the non-unionized employees of the state of Connecticut. So all of those employees are participating in the paid leave program. Those unionized employees who collectively bargain to be included will also be covered if they vote to do so. Employees who work in municipalities or local or regional boards of education will be participants in the program if the unionized employees of the municipality or the local or regional board of ed vote to participate. If the unionized employees in either of those workplaces vote to participate in the paid leave program, then everyone who works there is part of it, whether they are in the bargaining unit or not. And you can see there is a very broad definition of municipality that runs from our general understanding of towns and cities and boroughs all the way to flood commissions and regional emergency telecommunications centers. The contributions that have been collected starting in January are managed in this way. The employer, collects 0.5% of wages from the employee and remits those to the paid leave authority on the cadence and according to the calendar that I outlined in the previous slide. Those contributions are post-tax and they are based on the employee's wages as those wages are calculated for FICA. They're also capped at the Social Security contribution limit of $142,800. The Pay Leave Authority receives those contributions and validates the wages upon which those contributions are based by information that we receive from the Department of Revenue Services and the Department of Labor. The contributions are then deposited into the Paid Leave Trust Fund, and that is the trust fund that funds the benefits that are paid starting in 2022. Let's have a brief overview of the leave laws themselves. What exactly is covered by the paid leave program? Excuse me. All right, so we know that if you're a larger employer, meaning those that probably have 50 to 75 employees or more, you're covered by the federal FMLA as well as the state FMLA. Those laws, the federal FMLA will continue to exist, and there will be changes to the Connecticut Family and Medical Leave, which I will review in a moment. Workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and what we call SFIPA, which is the Connecticut Fair Employment Practice Act, all continue to be viable laws in the state. And they offer some form of job protected leave, meaning that there has to be some sort of a dialogue with the employee if they take a leave under any of these laws, so that their job is protected when they return. Those laws that will require income replacement or provide it will be the Connecticut paid leave law when it changes in 2022, and workers' compensation will continue to be available, with a note that a person that is receiving workers' compensation is ineligible to receive benefits under the Paid Leave Act. Here's a more succinct comparison between the Connecticut Family and Medical Leave Act as it currently exists and the way that it will change next year. Right now, it applies to employers that have 75 more employees. And in order for those employees to be eligible for that leave, they have to work for their employer for at least 12 months. It doesn't have to be consecutive, and 1,000 hours. After that, they exercise job protection, meaning they're entitled to get their job back or an equivalent job when they return from family and medical leave. They can now get 16 weeks in a 24-month period, with the exception being 26 weeks for military caregiver leave. And the employer can require the employees to use all of their accrued time, whether it's vacation, sick, or PTO, to cover all of the time, part or all of the time that they're away on medical leave. Next year, the law will change significantly. It will apply to all employers with one or more employees. There will be no hours worked requirement, and the job protection that attached after 12 months will now attach after 3 months. Those who exercise their right to have to have family and medical leave will have 12 weeks of leave in a 12-month period. The 26 weeks of leave remain available for family caregivers, for military caregiver leave, and there will be an additional 2 weeks of leave that might be available if someone experiences an incapacitation during their pregnancy. And finally, the most significant change between the current and the new law will be that an employer can require an employee to use their accrued time, but they must allow them to keep up to 2 weeks of their accrued paid time off, however that is managed in the workplace. Some of the reasons for leave and for income replacement benefits include creating or expanding your family through birth, adoption, or foster care. To care for a family member with a serious health condition, which is also known as family caregiver leave, or your own serious health condition, which can include serving as an organ or bone marrow donor or pregnancy. As I mentioned earlier, there is special leave available to care for a family member that has been injured during active duty. And there's also what's known as qualifying exigency leave, where a family member is called to overseas active duty. You can take time off to see that person off or to accompany them when they're putting their affairs in order before they deploy. What is unique to Connecticut is the ability to take up to 12 days of leave if a person is a victim of domestic violence, which is leave that's available under our state's family violence leave law. Besides the differences that I've outlined earlier, the primary difference between the federal FMLA and the Connecticut law will be the expansive definition of family that will attach come next year. Right now, under federal FMLA, a person can take leave to care only for a parent, a spouse, or a child that's under 18 or over 18 if they have a disability. Next year, the Connecticut law will change to allow for leave for all of the categories that are listed here: parent, spouse, son, or daughter of any age, so no longer capped at 18, and especially those with whom the employee has a close relationship that is the equivalent of these family relationships, and that is known as an affinity relationship. So what does related by affinity mean? It does mean that any person with whom the employee has a significant personal bond that is like one of the family relationships that's listed in the statute, regardless of their biological or legal relationship. So an example of that will be, and our general counsel gave this example yesterday, let's say that there is a young adult who may have been asked to leave their home because for any reason they've come out to their parents and their parents have asked them to leave the home. There is an addiction issue or there's some other conflict, and that young adult has left the home. They then may relocate or move in with another family and may have lived with them for some time and now consider them to be their family. If someone in that family would need some help or support, as the law currently stands, that person would not be able to take any time off to take care of them. As the law changes in 2022, as long as that person can establish that it is a relationship by affinity, then that person would be able to take time off to care, for example, the family maybe the mother or the father that took them in that they now consider to be their parent. What is the length of leave that's available under federal, state, and paid leave? Under federal leave, as I mentioned earlier, that has not changed. It's still 12 weeks in a 12-month period with up to 26 weeks available for family caregiver leave. The same amounts of leave are available for Connecticut job protected leave and for paid family and medical leave, which we've reviewed before. The eligibility requirements for federal leave still have the number of months that need to be worked and the number of hours that need to be worked prior to the time the person takes the leave. In Connecticut, there will no longer be, starting next year, any hours worked requirement, and job protection is available after 3 months. In order to access paid leave benefits, however, a person has to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters that they've worked. They must also have a qualifying reason for leave, and they had to have not exhausted their leave time. In addition, they had to have been currently working in the state and employed, or they were employed in the state for the 12 weeks immediately prior to the time that they applied for leave. Those that are sole proprietors or self-employed individuals obviously are also eligible if they've opted into the program and have made a contribution. So the role of the employer looks like this, whether you're currently in an employer that's covered by Connecticut Family and Medical Leave, or if you will be come next year. So every time an employee comes to ask for time off for what might be a potentially family and medical leave qualifying reason, the employer really should be asking 2 questions: whether or not that person is eligible for job protected leave under the statute. They can also, as an addition to that, just ask whether or not they have a qualifying reason for leave. And if they do, if the person is eligible for any income replacement while they're on leave. And it's important to ask both of these questions because there might be circumstances where there may be no job protection, but income replacement, and there might be both. So there might be both job protection and income replacement. So it's important to ask both questions. And here's why: because an employee can be eligible for federal leave only, state leave only, for both that might run concurrently, for neither, but perhaps as a job protected leave as a reasonable accommodation, which is very common under the Americans with Disabilities Act, and it's also very common under the Connecticut Pregnancy Disability Law. Or there may not be any job protection at all, and that's why it's important to ask the questions. So here's some facts about income replacement. So let's assume a person is eligible for leave and they also have a leave that qualifies for income replacement. A person can receive both their employer provided benefits and benefits from the paid leave authority, but those combined benefits can't exceed 100% of the employee's regular wages. Short-term and long-term disabilities sometimes require that the employee exhaust all of their state available leave first, but there will be coordination between the paid leave authority and the employer to coordinate those benefits. As I mentioned before, you cannot have a person both on workers' compensation and paid leave at the same time. There might be some circumstances where a person is eligible for paid leave but may not have job protection, and it would work this way. An employee could come to you as a new employee, having worked elsewhere in the state. They may have earned that 2325 I spoke of earlier within the highest quarter of the last 4 or 5 quarters that they've worked, and they may have met all of the other criteria for paid leave, but they have no job protection because they've not worked with you for 3 months. You might allow them to go ahead and take their leave, but you do not have to hold their job for them. And that's a conversation that should be had between the employee and the employer before they decide to take leave in a time period where they don't yet have job protection. I will review private plans in a moment, but an employer also has an option of providing a private plan for their employees if in fact there is an option they would like to exercise and ask their employees about with respect to not participating in the public plan. And finally, if an employer requires an employee to use their sick, vacation, and other leave, they have to allow them to keep up to 2 weeks of leave. If you offer just PTO or paid time off in a general bucket and it's not necessarily broken up by sick, vacation, or other categories, then the person is entitled to hold on to 2 weeks of their PTO. If you do offer it in terms of sick and vacation and personal, most employers that we've spoken to are requiring people to exhaust their sick leave first in order to avoid what's called stacking, which is a person holding on to their sick leave while they exhaust all other kinds of leave and then come back and then use that leave. But every employer is using a different approach. So as long as you know that you have to allow people to keep up to 2 weeks of their leave, then how it's managed in your workplace is something we leave to each employer. Employees will access paid leave benefits by applying directly to the paid leave authority. This is not a process that is managed by the employer. So once a person has applied for leave to the employer and you have approved their leave away from the workplace, they will come to the paid leave authority. We will then determine their eligibility based on all the criteria that's in the statute and making sure that the reason that they're taking leave is one that's covered by the law. We do a preliminary calculation of their benefit, but then we go back and have communication with the employee and the employer to validate their actual covered absences and to see whether or not there is any offset that is provided by the employer, whether that is sick or vacation, short-term disability, or any other type of leave that would impact their benefits payments. And after that calculation is complete, then we issue benefits payments to the claimant. And the formula for the paid leave benefits looks like this. If an employee makes less than or equal to the minimum wage multiplied by 40, they will receive 95% of their base weekly earnings. If they receive more than 40% of the minimum wage multiplied by 40 in wages, then they receive the 480 plus 60% of the amount of their base weekly earnings that exceed the minimum wage multiplied by 40. So essentially what that means is that as a base, they receive the 480. Then they receive the difference between the 480 and 60% of whatever it is that they make. But the maximum that anybody can get is $720 because it is capped at 60 times the prevailing Connecticut minimum wage. Here are a few examples. So Mike on the left makes $375 a week. So he makes less than the minimum wage multiplied by 40. So 95% of his wages would be $356.25. Deborah, on the other hand, makes considerably more. So as a base, she will get the 480, and then she'll make the difference between what she makes and the 480. She'll get 60% of that number and end up with $612 a week in her paid weekly benefit. What about spouses who work for the same employer? This is often true in employers of every size. The federal law, if that is applicable to the workplace, does not change. Spouses are required to share their 12-week job protected leave to bond with a newborn child or to care for a parent with a serious health condition. Spouses are required currently under state FMLA to share their leave to bond with a child who is a newborn, I should say also new to their family, or to care for a family member with a serious health condition. When the Paid Leave Act comes into effect next year, there is no requirement to share the paid leave benefit for any reason. So a bit about private plans. You've heard me speak about this before. The statute does allow an employer to offer a private plan to meet their obligations under the Paid Leave Act. If an employer chooses to do so, then it's the employer and not the authority that administers the employee's claims for paid leave benefits. But that employer is not required to collect any money from the employees that is remitted to the paid leave authority. They can withhold a portion of the employee's wages for the purposes of offsetting the cost of administering the plan, but that withholding cannot exceed 0.5%, nor can it exceed whatever level the paid leave authority sets as the contribution rate, which might be lower than 0.5% if that's feasible. Employer chooses to apply for a private plan, that can be done on our website, ctpaidleave.org, where you would choose the option on the front page, I want to apply for a private plan. Your plan requirements have to offer same or better benefits as the public plan, and generally a short-term disability policy does not suffice for a number of reasons, not the least of which is that the private plan has to be approved by a majority vote of all of the employees working in the state. And it has to cover all of the employees, meaning that there can't be a different plan that's offered for those that are in executive levels or senior management, as an example, than what's offered to the rest of the employees, nor can a different plan be offered to unionized employees than non-unionized employees. And it can never cost employees more than the public plan. There are, as you can see, a number of insurers that have offered to provide a policy for a private plan in the state of Connecticut. I'm not going to count, but I think we're up to 14, and not all of them, I believe, are on this slide. I think another was approved a few weeks ago. So all of these insurers are offering a private plan. Some of them are also offering what's known as a self-insured plan, meaning that you have to get a surety bond that runs to the benefit of the paid leave authority that is equivalent to the contributions that you would collect from your employees if you choose to be self-insured as a private plan. I've said a lot today, but one of the things I would really like to emphasize is registering your business if you've not already done so. First of all, I want to say thank you to the 66,000 businesses that have already registered with the paid leave program, and to tell you how grateful we are for your cooperation. But registration allows you to remit your employee contributions, which are due at each quarter with a 30-day grace period. What's important to know is that if you're not registered, you won't be able to remit those contributions. Also, we don't want employers to run into any kind of difficulty. If you're not withholding, please start now, because there is a small window in which you can have some catch up, meaning that you can retroactively go back to your employees. Sorry, that was redundant. You can react retroactively withhold the 0.5% from your employees. The Department of Labor has approved what's known as a catch-up period, meaning that if you haven't started to withhold, you can go back to January, but you cannot withhold more than 1% of wages from each pay period. So starting to do that now is really important, and you'll be able to do that through June, which is the end of the second quarter of the calendar year. Failing to withhold and remit these contributions can affect an employee's ability to receive benefits, because we will be checking to see whether or not that employee has made a contribution. So we don't want employers to face additional penalties, which really would come in the form of any kind of catch-up that you could not get from your employees because of the DOL rules. So in order to do that, it's really important to register and withhold right now. The registration process is really quite easy and can take you less than 10 minutes. So here are some screenshots to show you how to do that. When you go to ctpaidleave.org, it is one of the first things you'll see on the site. You just hit get registered. You will create an account with ct.gov. That will give you credentials that will allow you to come back to the site and sign in and get ready to register. You can also see that it will allow you to choose the tab to apply for a private plan. You can do it all on the ctpayleave.org site. I've said a lot today, I know that. I recognize that there's a lot going on, but we have a lot of resources on the website, and they include posters and a paycheck mailer that you can give to your employees so that they can understand how it works. And these are not limited to employees. So if you had some information that you wanted to know about as an employee, you can go to, there's a page for the employee, for the employer, for sole proprietors and self-employed individuals, and it's all downloadable. There are also videos, and there are frequently asked questions that are on the site as well. For employers, we have a complete employer toolkit that includes everything that I just spoke of today. Again, I really strongly encourage everyone to go to our site, ctpayleave.org. And for employers, here is what we're asking you to engage in as immediate action: to register, as I spoke of. So if you use a payroll provider, a tax accountant, or any kind of third-party administrator, to make sure that they're aware. Almost all of them are, because we've been in contact with them for many, many months now. And if they're not, please let us know that, because then we can have that conversation with them as well. To educate yourselves and your employees about withholding, you can do that by visiting the site and getting all of the documents that I've noted in the previous slide, and to visit the site regularly, because we do update it quite frequently. I want to thank you, and we do have a site where you can reach us. We don't have a call center to speak of, But if you go to the website and you use the Contact Us portal, which I can tell you that thousands and thousands of people are doing, you can submit a question, you can ask for a call back, you can ask for an agent that speaks Spanish, and we can help you with that as well. There are also lots of frequently asked questions and helpful videos on the site. Thank you. And I'll stop sharing my screen and come back on video. Okay. So
Hi, Andrea. Thank you so
thank you.
much.
Thanks, everyone.
So we do have some questions in our
Sure.
Q&A.
Sure.
So we'll start at the top and work our way down. The
Sure.
first one being, should payroll include the salary for an owner employee?
No, you don't. If you're, well, let me answer it a different way. If you're a sole proprietor, you have the option of participating, so your salary doesn't have to be included. If you receive a W-2, like your employees do, then you're considered an employee who should be participating in the plan. And yes, so your salary information that is based on your withholding should be included.
Okay. And this says we use JustWorks as a PEO who process our payroll. Do they deduct for us, or does the employer have to do this separately?
Your PEO should be doing this for you. And the PEOs were a new category of third-party administrators that we just became aware of a few months ago, but we've been actively working with them. So they should be withholding that for you. And if they're not, then that's a conversation you should be having with them. But they have explained to us that they will be managing that process for you.
Okay. Will we be covering, and we actually have several questions in regards to how to submit payments. So
Yeah.
the general overall question is, will we be able to go over with everyone how to submit their payments on 4/30/21 and what
We
format?
will. We will. So we are actually testing right now the payment processing so that we can make sure it works the way we want it to work for you come March 30 or April 30. So when that functionality is working precisely the way we want it to work as well as the website does, because we know that people really enjoy the way that the website is easily navigable and the information is available. Then we will announce that the payment processing is available, and there will be training material and more webinars on how to submit payment.
Great. If a school, a private school, which has always been exempt from paid leave laws, why aren't companies under 50 people also exempt? Because we too have always been exempt from having to provide paid leave.
Yeah, I think we've never had paid leave, so I think you've been exempt from family and medical leave because of the size of your business. And all I can tell you is that the statute has been changed to include all employers, one or more employees. There had been a lot of negotiation before the law, which predates me, quite frankly. I'll just say that. So I wasn't privy to any of those conversations. But I know that in all of the negotiations to create the law, that it did lower the threshold from 50 employees to one. And I hear this often, and I understand and appreciate how challenging this can be. I really do. And it's one of the reasons that we are doing so many webinars. Is probably we're closing in probably on 110, 115. Amber, you can tell me what the number really is. Continuing to reach out to small businesses because we know that the landscape of family and medical leave is brand new to small employers. So right now, as the law exists, it applies to everyone who has one or more employees. That might change in the future. I don't have any indication that that's the case. But while it exists and the way that it does, our role here at the Leave Authority is to really try to help you navigate that as much as possible. And we do take all of the feedback that we get in every single webinar, and we do share this with the legislators and the key stakeholders so they can know and hear and understand what concerns are being raised about the law itself.
Thank you, Andrea. The next one is, good morning. Is overtime for hourly employees factored in to paid under this leave?
It is. So it's overtime, bonuses, other kinds of monetary compensation are all considered wages as defined by the Connecticut Department of Labor. So, and it's also the definition of total wages in the statute. So all of that is included. And so, yes, it is part of the 0.5%. It also, however, gets you to the 23-25 that needs to be earned in the highest earning quarter much faster so that you can have your eligibility for benefits happen more quickly than not.
Okay. The next one is in regards to staffing services and agencies. How would job protection play out when the employer is a staffing service and the worker is a temporary worker who has worked longer than 3 months?
Okay. So if the person is a temporary worker with your agency, are they an independent contractor or are they a temporary worker, meaning that they kind of move from assignment to assignment, but they're your permanent employee? Because those are two different scenarios. So if the person is a permanent employee that you move from one assignment to another temporarily, then they would be covered by the paid leave law. You'd have to withhold the 1/2 of 1%. If they're a independent contractor for whom you provide temporary work, then you do not have to withhold the 1/2 of 1%. They are considered independent contractors and they have the option of participating in paid leave or not.
Okay. The next says, I have a floral business on the side and I get my payments taken from my current employer. Do I still have to register my business?
No, so if you're the owner of the floral business, if you have employees, they need to they need to participate. So you need to register your business in order to withhold for them. But if you're the owner of the floral business and let's say, you're the sole proprietor or the only employee, then you don't have to register your business and your employer should already be withholding and in your other employment.
And do we need to deduct for 1099-S?
No, you do not. No 1099 deductions.
Okay. The next one is asking, will we be getting a quarterly report of payments made by the employees and who provides that?
So right now there is not a plan to provide a quarterly report as of March and April. But if an employer were interested in knowing how much had been contributed, then those are questions that we will be able to answer. But we wouldn't have the capacity right now, not forgetting we're a brand new business, brand new authority to distribute those reports to all employers because there are at a minimum 110,000 employers in the state that are considered um, this is the term that DOL uses, viable businesses, meaning those that contribute to unemployment insurance, meaning those that are required to. So right now we don't have the capacity to do that, but the plan is to be able to offer the ability to log in and access that report and rather than have us send them to you. But we're working on that as we speak.
All right. And is the employee who actually works outside of Connecticut exempt from this tax?
Yeah, so if you work outside of Connecticut, then you don't have to have the withholding. If your employer has their headquarters outside of Connecticut, but you work here, then you do.
And how complicated is the upload going to be? Will a business be able to accomplish this on their own?
The upload for private plans or for the payment. So the payment upload, it won't be complicated. So if you've already registered, if you have gone in to see what's known as the My Account feature, where you can kind of see everything that you've already done with respect to your business, it will be that simple. But it's one of the reasons why we're continuing to test the payment feature because we want it to be as easy and as simple as what you can do right now. But it won't be hard. You won't need a lot to be able to do it.
Okay. And the next is, can you talk about student employees of an educational institution? Are they exempt if they are from a state that is not Connecticut?
Yeah, this continues to be an outstanding question. The way that the statute defines employee is anyone really who works for the benefit of the business. And I'm just paraphrasing. So right now, student employees are covered, even though I understand and I do know that some of them are not subject to FICA. But we're continuing to get some clarity from the Department of Labor and also, quite honestly, from the Attorney General's office to see if that is actually the way that the statute should be interpreted. And while we wait for that, however, the way that the statute reads at this moment, student employees are considered employees and there is a withholding for them.
Okay. Let's see. If our payroll is making the deductions, then will they also make our quarterly payments? So we've actually had this question a lot. So
Yes,
for the others that have asked, yes.
yes, they're responsible for both.
Okay, great. And I believe that concludes our questions for the moment. If
Okay.
anybody else has any other questions, please submit them in the Q&A. Okay. If we want to file for a private plan option, when does that have to be done? Could we file in Q2 of 2021 to be effective retro for one, or does it fall to July 1st?
So it would fall to the following quarter, which would be July 1. What we're telling employers is that it would be better if you could make that decision sooner rather than later, because we really want you to submit your application no later than March 15th, which is only about 3 weeks from now. And we are trying to turn around in decisions. We're actually doing it now in no fewer than 2 business days, even though we have given ourselves 15 business days in which to determine whether or not a private plan can be approved. Uh, no matter what you decide, we tell employers to please withhold the 0.5%, even if you hold it in escrow until the time that your plan can become available and your employees vote on it, or you decide to implement your plan and make it live. It's important because we don't want employers to be responsible for any of those withholdings while they're waiting to make a determination about a private plan or waiting for an employee vote.
Okay. And for short-term disability, there's an 8-day unpaid waiting period before the benefit kicks in. Will this be similar for the Connecticut paid leave program as well?
No, there is no waiting period that's defined in the statute for family and medical leave program in the state when it changes next year, I should say.
Okay. We do have one more question, but I'm asking them to rephrase for a little clarity so we can answer
Sure.
that for them.
Okay.
So in the meantime, everyone, I'm going to drop a couple of links in the chat, and we will answer your questions as they come in. So the one we have right now says we have 2 locations with employees. One is in Connecticut, one is in Virginia. We run separate payrolls, and some employees that are physically located at the Connecticut facility are paid out of the Virginia payroll. We still need to deduct 0.5% for those employees.
Yes, so you do need to deduct 0.5% for the employee that is working in Connecticut, even if the payroll functions are managed in Virginia. You will have to do that. It would be similar to the way in which you would also pay your unemployment obligation or your payroll tax obligations for that particular employee in the state. It would be the same philosophy would apply, I should say.
Okay, thank you, Andrea. So again, that kind of concludes for the moment. Everyone, I'm dropping in the chat the link to our calendar of events. We are offering several webinars on different topics. And if any of you would be interested in joining us for any of those, you can visit our calendar of events at the link that I've dropped in the chat to join us for those. Our next question, if a worker is sent to a company through a service on a hire assignment, they work for 5 months and then take the leave, will the company where they are sent to be required to take them back after leave?
Right, I'm looking at the question. Let me make sure I understand it. So a worker is sent to a company through a service. If the worker is your permanent employee, let's start with that premise, whether that's true, and then they go to work for the employer on attempt to hire assignment, and they work there for 5 months. So it seems that no matter what, the person that's being sent is still an independent contractor, because if they're not an employee of the service, then they're considered an independent contractor, and they can opt or not, but the service itself is not required to withhold the 0.5%. If they are your employee and they work for 5 months at, let's say, their temp assignment and they take the leave, the company where they are sent is not required to take them back after the leave. They are not considered an employee of that company. They're either considered your independent contractor or your employee, depending on what your relationship is with them. But the company where they are working is not required to take them back, unless, of course, after the temp to hire, they hire them permanently. Then they are their employee. Now the question there is, when does the clock start? Right? Did the clock start when they were their temp to hire, or did the clock start when they hired them permanently? And the answer to that is that the clock starts when they hire them permanently, because then they are that employer's employee, and their 3 months for job protection starts at the time that they are hired, not the temp to hire. That time period, they weren't on that employer's payroll. They're not considered their employee, so that time period doesn't count towards their their 3 months of leave of job protection time.
Okay. And it looks like that's all we have for questions right now, Andrea.
Okay, all right. I'm happy to give people back time in their extremely busy days. So Leslie, I don't know if you're still there.
Yes, I'm here. So
Okay.
thank you both.
All right. So thank you very much for the opportunity to present to you today. If you have any other questions, please let us know. And thank you again. Have a great day.
And thanks everyone. And we have recorded this, and it will be on the library's YouTube channel. So just so you know, in the next day or two. So thank you, Andrea.
Perfect.
Thank you,
Thank
Emma.
you.
See you
Thank you
again.
so
Thank you. Have
much.
a great day.
Bye.
Okay. Bye.